My lord, I want permission of lordship, my lord, for moving a bail petition, my lord, today, if possible, my lord, kindly. I am filing it, my lord.
You have not yet filed.
My lord.
Then I don't think it will be possible today.
At 2 p.m., my lord, at least, my lord.
2 p.m. I have another.
Before rising, my lord.
Because
before rising, my lord.
I don't think today is possible because see, you are not used to our. See, I have
That's right.
single bench, then another division bench.
That's right.
Then in the afternoon another one.
Then tomorrow, my lord, kindly.
Tomorrow maybe.
Tomorrow, my lord.
Okay.
Oblige.
Lordship, item number 4, where I'm appearing for the MIDC, Lordship, your Lordship had sent it for settlement between among the negotiation and settlement among the parties. So the settlement could not be made because they could not meet. The government was preoccupied and they didn't come for the meeting. So I'm told now again it's on the 25th of this month, but my prayer is that your Lordship may send it for mediation, since the mediation is on here under the mediation nation as well.
But the other side has to agree.
The other side, government had just discussed it with me. I don't know, none of them have come.
Let it be called up then. Otherwise, without the other side being present,
Okay,
you
Lordship.
can't really,
Yes.
can't really pass an order.
Okay, oblige you, Lordship.
Supplementary list, item number 1.
May it please your Lordship. Lordship, here the petitioner number 1 is the son of Fulbahar Sheikh. And the petitioner number 2 is the real brother of Fulbahar Sheikh. And the petitioner number 3 is the cousin brother, Lordship. There are 3 petitioners in this case, Lordship. And why I am referring, Lordship, that Fulbahar Sheikh, Lordship,
Yes.
because he is the secretary of Village Defense Party of Marashuti Village, Lordship. He is the one of the responsible person of the locality, Lordship. Now, Lordship, the deceased here, Lordship, he was a drug addict, Lordship. So he's a drug addict. This is on record, Lordship. Now, as a responsible citizen, as a responsible person of the society, that Mr. Fulbahar Sheikh, he is connected to the police in all. So some responsibility was assigned to him to oversee all those things, Lordship. Now that boy, the deceased, he under the influence of drugs, he creates lots of problem within the village as well as in the market also, Lordship. There are numerous FIR against him. I just found 2 FIR, Lordship, against the deceased, Lordship. Lordship will find at page these 2 FIRs at page 12, Lordship.
This is
the FIR against the deceased, Lordship. Why I am saying, Lordship? Because I just want to show that he was involved in so many cases, Lordship, because of its habit, Lordship. Then page 12 is
this is some murder case.
murder case, Lordship. I'll come to that, Lordship. Page 12, Lordship.
Yes.
This is the FIR file. One of the not villagers, he is from that market, New Whiteberry Market, Lordship. May I read the type copy, Lordship?
Yes.
This is a registered case against the so-and-so. The informant is Paran Shah and the accused is Pullu Sheikh. His actual name is Aminul Islam, but his nickname. With reference to the subject cited above, I have the honor to inform you that my minor daughter, namely so-and-so, aged about so-and-so, who is reading in class 9 at Whiteberry Higher Secondary School, New Whiteberry under so-and-so, the above named accused is dangerous and disparate in nature. While my above named daughter goes to school, the above named accused tease her regularly on the way to school, for which my daughter feels discomfort. And my said daughter asks the accused person not to tease her. But the accused person does not stop teasing on so-and-so at about so-and-so, while my said daughter was going to school by Whitebury NAC Road, the accused person suddenly appeared before her with sharp weapons, wrongly confining her, threatened with dire consequences. Even the said accused threatened to kidnap her and finish her if she does not agree to make physical so-and-so. Finding no alternative, my said daughter could able to escape from hands of the accused by running away to school home. Now, Lordship, and again, page Lordship will find page 16, the type copy. The same person again file another FIR, Lordship. Why I am pointing, Lordship? There are numerous cases against the deceased, like that assault and all other, Lordship. Now on 28, Lordship.
See, Mr. Sheikh, let me understand quickly. I have not gone through the petition.
Yes, Lordship.
What I can understand is this. The deceased
Yes.
may have been,
Right, Lordship.
murdered or
Yes,
killed,
Lordship.
whatever,
Yes.
in whatever
Yes,
circumstances we
Lordship.
don't know.
Yes, Lordship.
And you are the suspect.
I am the suspect.
You are the suspect.
Suspect.
Whatever the case may be. So that is the fact of the matter.
Yes, Lordship. I am coming to that, Lordship.
So, what you are trying to say is that you are recalling the antecedent of the deceased, his involvement in many criminal cases, to justify that.
No, Lordship, why I am coming, Lordship, that is why I took the name of Fulbahar Sheikh, Lordship. Why I took the name of Fulbahar Sheikh. Now the incident, because of that only, Lordship. Kindly come to page 17, Lordship. Now I'll come to the fact, Lordship. Page 17 is the FIR lodged by the village defense secretary of the village defense party. Now on 28 June 2025, Lordship, when some villagers, because that person Fulbahar Sheikh also resides in the same village as well as the deceased, so reported some antisocial activities of the deceased. Then it is not that he was shouting at him. As a responsible person of the locality, he tried to persuade him that don't do all those things and let to a normal life. Then what he did in the evening, Lordship, while he was coming, that Fulbahar Sheikh, that is prior to the incident, Lordship. That FIR was lost on 21st, prior to the incident. Fulbahar Sheikh, while he was coming to his home from Bazar, Lordship, 7:45, Lordship, he was waiting for him because he just give some lessons to him. He was full under the influence of drugs. He was waiting and he chased Fulbahar Sheikh. And because of the intervention of one person, he was safe. He could not be attacked. Now, Lordship, that is why the Fulbahar Sheikh filed FIR prior to the incident, Lordship. Now, on the evening time, Lordship, in the evening time, when the deceased came to know that Mr. Fulbahar Sheikh, the VDB secretary, the father of the petitioner, has lost an FIR against him, he got annoyed and he was looking for Mr. Fulbahar Sheikh. Where is Fulbahar Sheikh? Now, the FIR was filed on the same day morning for the incident which had happened on 28th night. Now, in the evening of 21st June 2025, he was looking for Fulbahar Sheikh. Now, the Fulbahar Sheikh, after offering his evening prayer, Lordship, at around 4:20 to 30, he was waiting in a shop near the village. Suddenly, Lordship, the deceased came and attacked with sharp weapons down. Immediately, Lordship, because the injury was so grave, Lordship, he hit on his head. So he was taken to the nearest CHC, Lordship, that Bhaitbari CHC. Now, after he was brought to the CHC, my Lord will kindly see the timing, Lordship. Timing, what time he was brought to the CHC, Lordship. Now, he was brought to the CHC at around 4:30, Lordship. Now, after that, what happened, when the information of the attack of Fulbahar Sheikh spread to the locality. Now the villagers and the surrounding areas, peoples, they says the deceased lordship, that the assailant. And after almost 500 meters he was running, then the villagers got him and thrashed him, lordship. Now lordship will kindly see the report, that the incident was reported by the digital media, the news portal, as well as the print media, lordship. Immediately after the incident, my lord will finally page 25, lordship. This is one of the print media, the Meghalayan Express. This is immediately after the incident. My lord, a man with reported mental issues has died after a mob assaulted him for stabbing a villagers in the plain belt region of Rajawala, so-and-so. Rajawala police received a telephonic report around 5:15 p.m. that a man who was mentally unsound, identified as so-and-so, had taken a dhow and stabbed one villagers by the name Fulbahar Sheikh. He is my father. On the Marashoti road before attempting to flee. A mob of villagers gave chase and caught up with him near Durga Mandir in New Bhaitbari. They gave him a public thrashing, resulting in the attacker sustaining grievous injuries on his head and the body. He died on the spot. Now my lord will see the next page, lordship. It was a mob killing, lordship. Now, lordship, he was hospitalized. My lord will take the Shillong Times, lordship, on the next day, lordship. That is at page 27. 26 is also another print media report. 27, lordship. This is Shillong Times, lordship.
No, okay. You have proved that point. Any FIR file?
That is why I am saying, lordship, on the next day, lordship. On the next day, lordship, now all the media, digital as well as the print media, saying that it was a case of mob killing, lordship, because he was so-and-so, as a result of the attack of Fulbahar Sheikh. The blazers seize him and attack and thrust him to death, lordship. Now on the following day, lordship will find page 28, lordship. Page 28. Page 28, serial number, lordship, 10, lordship.
Yes.
10, date and timing of the FIR, lordship. The incident of mob killing happened at 5 to 5:15, lordship. The incident of assault to Fulbahar Sheikh happened nearly 4:20 to 4:30. Now on the next day, lordship, 2:30 p.m. Now the brother of the deceased, lordship, lodged a complaint, and the distance between the place of occurrence and the thana is almost, this is written 5, but less than 5, lordship. Now on the following day, he has filed an FIR against all the sons of Fulbahar Sheikh, including myself, and all the relatives, 13 accused, including the Fulbahar, lordship. Lordship will find the name of the accused, lordship, at page 30, lordship. Type copy. Page 30. My lord, got it, my lord?
Yes, yes.
Yes, type copy. I am at serial number 7, 8, and 11, lordship. Now these 3 persons, lordship, now after the incident, now the prime suspect, lordship, one of the son of Fulbahar Sheikh, one of the son-in-law of Fulbahar Sheikh, and one relative, they have voluntarily surrendered on 11/7/2025, lordship. They didn't approach to the court, lordship, for seeking anticipatory bail, lordship, because they knew that they were somehow involved, lordship. They have surrendered voluntarily. Now this out of 13, lordship, including the Fulbahar Sheikh, who was also one of the victims, his name put in serial number 13. Now the petitioner herein, they were not at the spot, because moment the incident of assault happened to Fulbahar Sheikh, my lord, when such incident happen, nobody will look for the assailant. First, the primary concern will be to save the life of the victim lordship. Immediately, the victim was taken to nearby CSC lordship and accompanied by the one son and two brothers lordship. Now, when they were in the while they were inside the hospital lordship, because the timing to arrive in the hospital as per the report says 4:30 p.m. lordship. Now the incident happened between after 4:30 p.m. lordship, between 5:15 lordship. Now they were not present at the PO. After that primary treatment lordship, these victim, that Fulbahar Sheikh, along with that petitioners, they were for better treatment, they were referred to Gwalpara Hospital lordship. Now,
Okay,
lordship,
you have a plea of alibi.
yes, lordship, I have not come for, my lord will kindly, I have approached to the court, my bail was rejected. Lordship will see the brief history of the facts of lordship, page 24 lordship. That is reflected in the rejection order lordship.
Page 24.
Yeah, 34 lordship. My lord got it?
Yes.
Page 34, that is the rejection order lordship. Interim was initially allowed. After interim, the final, after hearing that my interim did not make absolute lordship and rejected my bail. Order of the so-and-so. Golay Hussain, Abu Taher, Syed Ali, Golbahar, so on. These are the names, so-and-so. Now I'll see lordship para, second para. The brief fact of the case as per records lordship, is that on 21st/6/2025, a telephonic information was received from one Harul Islam that
You have narrated that, so
yes, this is here. Even the police also says that yes, it was a case of mob attack. Now subsequently, my lord, brother of the victim, that deceased, that putting all the sons as well as the relatives of the victims of the assailant, that they were the prime accused in the instant murder case lordship. Now, my lord,
what is the stage of the case?
my lord, this investigation lordship.
Yes, Mr.
My case
Sengathai.
that I am not involved lordship. I was busy with my father.
My lord, in the same order, my lord, it is written that the learned trial court, after perusing the CD, my lord, on merit to certain extent, has discussed it on merit and thereby rejected it. My lord, I pray that this is not a fit case for interim bail. CD may be allowed to be perused, and thereafter my lord will decide whether they will be entitled to interim protection or not, my lord. Because the trial court has dealt with the CD in detail, my lord, and thereafter has come to a conclusion that no, it is not a fit case to make the anticipatory interim bail absolute. So I am strongly objecting against the
Here only
interim
one
protection,
was
my lord.
allowed.
What is the date of this order is?
Date of this order is
23rd lordship.
23rd 7/2025, page 34.
I was on interim till that lordship.
Today we are
Today we are 13 lordship.
so almost 3 weeks have gone by.
No lordship.
They did not cooperate, it appears, my lord. So there cannot be any leniency for that purpose. Once they have understood that.
I'm just calculating the date
Yes, my lord.
when this order was passed.
Yes, lordship.
Their bail was interim bail was rejected.
Yes, my lord.
Rather, the petition was rejected. So, from 23rd, they are,
Evading.
I don't know whether they are evading or not. It is incumbent upon the IO or the police to take them to custody.
Yes, my lord.
But that was not done. And now we are after
And even when they got the interim, my lord, they could have.
Lordship, almost 19, 20 days, Lord, 19 days.
Yes, 19. So after
92
19
weeks.
days,
When
2
they
weeks.
were under in the interim protection, my lord, they could have availed the to cooperate with the
No,
investigation.
they have
and
cooperated,
everything.
Lordship. That is not the reason. Now, one of the brother of the
no, Mr. Sheikh, the reason I'm saying so is the issue of apprehension.
yes,
When for so many days nothing has happened to you,
my lord,
after the order was passed, you have not been arrested.
my lord,
Where is the apprehension?
my lord will kindly murder sirs.
And number two, of course, it just occurred to me.
Yes, Lordship.
One forum has decided your matter on merits.
On merits.
On the same facts and circumstances, you have come before this court. Whether that is allowed or acceptable.
My lord will kindly.
Because you see now at this stage, of course, you have not come for revision of the order or appeal.
No, my lord.
But the fact remains that you have to, if you are to make a good case before this court, then you have to cite changed circumstances. Then you have to cite what was the attitude or the conduct of the IO towards you, whether whether he has approached you or whether he has directed you to appear or whether there's
My lord,
any likelihood of
my lord, there is an apprehension, my lord. Once that anticipatory, because Lordship, anticipatory bail is rejected, Lordship. It is not that I have. My lord will kindly appreciate they are from less, and it is not that I have delayed for a 1 month or so and so. And it is not a case that I can challenge the bail order, Lordship. Since remedy, though this is a concurrent jurisdiction session as well as here, Lordship, because I cannot challenge the bail order, Lordship. My lord is well aware, Lordship. I have to come a fresh bail application after rejection, and in many occasions, Lordship, I have seen my lord have raised if the the accused without approaching there directly come, Lordship. In many occasions, my lord have advised that you can, since that is another forum.
That is true.
That is why. So after that rejection, people will likely to approach here, Lordship. No, my only grievances here, Lordship. If you, Lordship, see the brief history of the case, Lordship, it was a case of now even.
My lord, the trial court has found a prima facie case, my
Call
lord.
for a CD.
Will my lord.
Today is by Monday.
By Tuesday, my lord. Monday will be 2 months. Tuesday.
What Mr. S.A. Sheikh led a counsel for the petitioners who have submitted that. Where is the FIR?
My lord, in the FIR, Lordship, I have put in the supplementary affidavit, Lordship. Because inadvertently that in the supplementary affidavit, Lordship, page 8, Lordship.
You have been named.
Name, Lordship, at that 7, then
Gunung
11. These are all the sons and daughters of Fulbar Sheikh.
Okay.
Even Fulbar Sheikh also, he got bail, Lordship. His bail was made absolute. That accused number 13.
An incident occurred on 21/6,
21/6, Lordship.
21/6/2025 at about 4 p.m. or so, where one person named Aminul Islam alias Bhulu was said to have been assaulted by a group of persons with armed with deadly weapons, as a result of which he sustained grievous injuries and sustained grievous injuries. So he died on the spot.
He died on the spot.
And died on the spot. Next, in this connection, the complainant is the
Brother.
The brother of the deceased had lodged an FIR before the officer in charge, Rajabala Police Station, West Garo Hills, on 22/6/2025. In connection with the said incident, the complainant had specifically named 13 persons in all as accused. That is, those who are alleged to have been involved in the said incident. Next, in view of the lodgement of such FIR, the 3 of such accused persons, who are the petitioners herein, have now approached this court with a prayer for grant of anticipatory bail. Mr. S.A. Sheikh, learned counsel for the petitioner. The learned counsel has, however, admitted that the said petitioners, herein had earlier approached the court of the Lalat Sessions Judge, West Garo Hills, Tura, for grant of anticipatory bail, but the same was rejected by order dated 23/7/2025. Hence this petition. Mr. S. Sengupta, learned additional PP, appearing for the state respondent, has accepted notice on behalf of the said respondent and has submitted that at this stage this court may be pleased to call for the case diary, since the matter is still under investigation, so as to know the latest status of the case, of the investigation. Next, this court accordingly, on consideration of the submission made, hereby directs the IO the said case was registered as Rajabala PS case number 15 of 2025 under section 103 under bracket 2 BNS. Last line of no. To produce copy of the CD on the next date fix. So 19. Sorry. Yes, 19. No?
My lord, can it be on 21st or 18, Lordship?
21st then. List this matter for the hearing on 21st.
Mark.
Item number 2.
My lord had asked for certain clarifications on
Yes.
two points. One, punishment and by the accused whether he has finished bonds after the anticipated is granted, and the second issue is with regard to whether he had surrendered his part. First issue, am I audible?
There's some
Am I audible, my lord?
some disruption from. There's some disruption from your end.
I'll speak it. I'm sorry. So
There are some technical glitch. Some technical glitch is there. Sorry, you're not so clear.
I'll reconnect, my lord.
Diary was also available.
But where is the local counsel?
Some
She was.
one colleague was there, my lord, yesterday, who was holding the diary also, case diary, which is required.
My apologies, my lord.
Yes, Mr. Ranja, you know what you're supposed to do.
Lordship, I have prepared, my lord.
Apology.
Your colleague is here.
My lord.
Actually, you're not required. You're not required for the present, because what is required is for me to produce the CD, and your colleague will be here to help me.
My lord.
Yes. Only with regard to the passport being impounded.
Lordship.
Where is the details here?
My lord, it's tab B.
Not clear. Can't read this. Can you read this?
Lordship, if I may assist, my lord, I think there's an extra copy. In
I
that.
have given yesterday, my lord, furnished some copies also to them.
Yes,
My
my lord,
lord,
yes. Because
this
it's a
passport has
letter
been cancelled by the passport authority. It is already cancelled.
My
I have
lord,
given.
my lord, if I may kindly, if my lord may have the letter, it's addressed to the accused himself. So yesterday I requested them also to help us.
This one.
But it's
Sir.
hard.
I think I have furnished, my lord, one letter intimation to the IO that passport has been.
If I may take you through it, my lords, actually what had happened was they had moved they have moved an application after the grant of anticipatory bail for change of address. I'll show you how, my lords. So on my lord, the anticipatory bail was granted on 24th September 2024. Now, if my lord may look at subsequent pages of the passport, it has been issued in Guwahati. Now, if my lord may come back to the letter that has come from Regional Passport Office Jaipur to him. This says clarifications required regarding issuance of passport facilities to Shri Gopal Krishan Gaur. So it means he has applied for issuance of passport. Dear sir, this is in reference to receipt of an adverse police verification report corresponding to an application for passport issue with file number so and so dated 8th October 2024. That anticipatory bail has been granted on 24th September, and on 8th October he's moving for change of address. And this has been admitted by him in his own letter to the IO that he had moved an application for change of address, therefore he doesn't have the passport.
Where is that
I
letter?
can show that. That is, my lord, that is unfortunately not marked. It is CD 26, dated 28th October 2024.
Just one. No, in your letter, Mr. Manan, in your letter to the IO,
Yes, my lord.
it is dated 4th December.
4th December 2024.
So you have indicated here that your
Passport we
original
have
passport was deposited.
in the office of passport.
Passport.
Yes, and then subsequently, my lord, it has been cancelled by the passport. I have enclosed the
That is
because of the case, criminal cases, many criminal cases. So it has been cancelled.
has been
My
cancelled.
lord, he
Yes,
had
madam.
moved for change of address after the grant of anticipatory bail,
That
instead
is
of surrendering the
okay.
passport.
That
You
much
see, we are not going to that. Not going to the
My lord,
passport,
it
issue
has been
of
cancelled.
passport.
why it was cancelled, why it was not.
admittable.
The fact is that it was only as you see with regard to the condition that was stipulated in the bail order
Yes, to surrender the passport
for the purpose of security.
so that he cannot abscond. So that has been cancelled already, my lord.
Fine.
And now, my lord.
So I've been clarified on this point, and that's all. I've heard the parties.
My
in
lord,
case.
regarding that furnishing of surety.
Oh, that's okay. You have admitted
Because
that
we
is-
have already furnished, as per the interim order, my lord, there was no such direction to furnish the bail bond. However, the IO insisted us to produce the two sureties. We have produced on 17/9/2024.
that was not in accordance with the order passed. The order was passed subsequently.
Yes, madam.
So there was no direction in the first interim order
That to
that
furnish
we have
surety.
to furnish surety.
But the IO
later,
has arrested and asked for surety.
whatever the case may be, that is, see, what the IO does is not the concern of this court.
Yes.
The only thing is that thereafter, when
Thereafter, my lord, we have not appeared
when you are
because
called
of.
upon to deposit,
Yes.
I mean, sorry, to execute the bail bond, you have not done so.
Yes. Thereafter, we have asked him, and we have given reason for not appearance, for our not appearance because of our sickness and all these things. Intimation has been made.
That is noted.
All right.
Thank you. So I'll pass this orders.
Madam. Daily list, item number 1.
here, my lord, we have challenged. This is the second round of litigation. My lord, here we are challenging the notice issued by the Forest Department, my lord, whereby they're seeking to resume a land which was initially allotted to me under lease.
Yes.
Are you sure? Okay. Now, your lordship may kindly see page 13.
You are in which case, Mr.
Lord, I am in. Show me the copy. No, I am in.
There are two similar, petition. Isn't it? You are
I
in
am
one
in
of them.
item number, my lord, 2.
422.
Yes, my lord, 422, my lord, and there are 2-3 matters, my lord, and 152, my lord, which is tagged with item number 3. 3.
What is this, Miss case for? This Debajani Devi?
My lord, there was an application filed seeking recall of, the order, my lord, by which a cost was imposed on us. My lord, but this application, my lord, seems to have become infructuous because we have already paid the cost.
Okay.
So, my lord, this application will not survive for any
It
consideration
has
anymore.
no connection to the
No, not
merits
to
of
the not to the facts of the case, my lord. And my lord, 3.
No, but this again, see this. I think this lady is also a petitioner in 423.
My lord, 4 yes, my lord. She is the petitioner in 423. She is the petitioner in 423 now.
So 422, 423 are
Connected. I mean, we are not connected, my lord, but they are all challenging the common action.
Yeah, common action, but separate notice.
Separate notices, my lord. Now, my lord, here what had happened, my lord, the lease agreement was issued to me, to my, my lord, to my predecessor. My lord, and my lord, the lease agreement, my lord, why? I'll take your lordship. Lordship may kindly have 423, my lord. That will have the comprehensive bearing on all the matters, because we had, my lord, earlier round, we had also approached this honorable court challenging the earlier notices. And there was an order passed in that particular case. Four to three, my lord.
Yes.
I'll take your lordship to the page number 15, my lord. But all the petitioners, my lord, who are here before your lordship, my lord, they have been settled with the land by way of a lease agreement. 3 petitioners, my lord. Not individually, my lord, there are 3 petitioners.
Okay.
So therefore, there are 3 writ petitions pending before this honorable court. Now, my lord, may kindly have page 15.
Yes.
My lord, this was a notice issued to us in the year 2019, my lord, whereby the government is seeking to resume the land which was initially allotted to my predecessor in interest under lease. Now, my lord, may kindly see notice dated 13 June 2019, resumption of forest land allotted on lease to private person. You are hereby informed that the lease pertaining to this plot of land was granted to Shri so-and-so, white dated so-and-so, and the lease agreement was extended by so-and-so. Therefore, the lease had thus expired on so-and-so. 2 consecutive notices were issued in this regard by the Divisional Forest so-and-so, so-and-so, respectively calling upon the then leaseholder to vacate the premises since government wanted to resume the said plot. However, the notices were ignored by the then lessee. It is learned that you have remained in illegal occupation of this plot of land till date, which was initially leased by the state government to Shri so-and-so, whose lease to has expired long earlier as aforesaid without any authority approval from the state government. You are therefore required to vacate the so-and-so within 1 month from today without fail, after which the government will resume the said plot of land. Now, Your Lordship, in this matter, once the lease was expired, my Lord, we had made a application seeking extension of lease. My Lord, that application still stands stands for consideration before the competent authority, my Lord, and it has not been disposed. Now, meanwhile, they issued this notice. My Lord, against this, we had moved this honorable court.
But
Now,
this
Your
notice,
Lordship,
this notice was not addressed to you. This notice was not addressed to you.
addressed to my Lord, he's a power of attorney holder. This gentleman is a power of attorney holder, my Lord, and the notice was issued to him. Of course, my Lord, through me, the notice was served on the original lessee. Now, Lordship, that order was challenged by us in that notice was challenged by us in writ petition number 251 of 2019. The order, Your Lordship, will find at page 16 and 17, my Lord.
Yes.
Now, I'll just take Your Lordship to paragraph 4. That's the operative portion. After hearing the learned counsel for the parties and perusing the writ petition without expressing any opinion on the merits of the controversy and the issues raised in the writ petition, the same is disposed of at this stage by permitting the petitioner to file a detailed and comprehensive representation against Annexure 10 before respondent number 2 within 15 days. It is, however, clarified that in case such a representation is filed, with respondent number 2 shall pass a speaking order thereof within next 1 month after affording opportunity of hearing to the petitioner interested party in accordance with law. Now, this was the order passed, my Lord. Thereafter, we file a comprehensive representation, my Lord, in terms of Your Lordship's order, which Your Lordship will find at page 18. Now, that letter, my Lord, I'll just take Your Lordship to the prayer portion, my Lord, at page 21.
Yes.
In view of the aforesaid, the undersigned humbly prays before you to kindly consider the case of the undersigned generously and favorably in renewing the lease of plot number 9 at Forest Colony, Shillong, the same being heritable and transferable in the interest of justice, and for which act of kindness the undersigned shall remain grateful and obliged. Now, Lordship, that representation was not considered favorably by the respondent authorities and was rejected vide on order dated 27 September 2019. The order, Your Lordship, will find at page 22. Now, Your Lordship, I'll take Your Lordship to the...
Are you still in occupation
Yes,
of
yes,
that?
very much.
Was there any interim order?
No, my Lord, after my Lord, we approached this Honorable Court, they have not gone further with the notice. The matter remains pending before this Honorable Court, and they have not really pressed upon those notices, my Lord. Now, I'll take Your Lordship to, my Lord, the order, which is at page 22.
Yes.
27th Feb. In substance, my Lord, what they say in this order is that, my Lord, it is a forest land. Now, under, my Lord, as per the Forest Act, my Lord, the Forest Act cannot be given to anybody, especially if it is a reserve forest. Now, my Lord, they further go on to say that the law is settled in Godavarman. They say, since it is a forest land, it cannot be given to any individual, which is a incorrect statement insofar as, my Lord, the records will speaks for itself, and the record shows exactly contrary to what they have stated in this order, my Lord. I'll take Your Lordship to the order first. 27th September 2019, the representation of Srimati so-and-so praying for extension of lease of plot number 9 situated at so-and-so protected forest. My Lord, may kindly see, there's a difference between protected forest and reserve forest. Insofar as reserve forest is concerned, my lord, there are restrictions. But so far as protected forests are concerned, the restriction for extension of lease or whatsoever are not there. I'll take your lordship to the relevant act, my lord, subsequently. Forest Act has been carefully perused. All the contention presented on her behalf on so-and-so during the course of personal hearing granted to her have also been carefully considered. Considering both her representation and contentions advanced during the course of personal hearing by her representative so-and-so, the following is ordered. Contention of the applicant in para 1 of the representation that patta has been granted to them so-and-so is misleading and false. No patta has been granted to the leasee, Shri so-and-so. Only a lease agreement was executed with him, which by no stretch of imagination is a patta. It may be noted that the lease of plot number 9 at Short Round for a protected forest has not been extended from time to time indefinitely. The initial lease of the said plot of forest land had expired on 31st December 1969. The lease was renewed thereafter for a period of 19 years by the state government. Now, my lord, may kindly say, sometimes they say protected forest, sometimes they say reserve forest. The applicant has conveniently avoided stating in her representation through that the DFO has already issued notice twice to the then lessee, Shri so-and-so, wide notice dated so-and-so and so-and-so, respectively, for vacating the premises, which has been admitted in the petition of Shri so-and-so, dated so-and-so, enclosed in the current representation of the applicant. It was also admitted therein that the said notice were issued pursuant to the direction of the state government, wide letter dated so-and-so, so-and-so, respectively. The state government wide memorandum dated so-and-so has ordered for resumption of government forest land allotted on lease to private person in so-and-so, categorically stating that the lease would not be extended anymore. Thereafter, the notices were issued so-and-so, respectively, calling upon the leaseholders to vacate the premises. The said notices were enclosed herewith as annexure so-and-so. The order of the state government dated so-and-so is enclosed as annexure 2. While it has been constantly claimed that the applicant is the wife and legal heir of late so-and-so, no documentary proof to the same has been furnished by her at any time to the state government while staying in the said premises before or after the expiry of lease period and that of Sri so-and-so. In any case, in spite of the relation quoted by the applicant, while the erstwhile original leaseholder, her occupation and lease of the said plot of government land is grossly illegal, since the lease were never transferred in her favor by the state government. My lord, may kindly appreciate one thing, Malad, this land, in terms of the conditions provided in the lease agreement, were inheritable and transferable to the legal heirs. That is borne out by their lease, the terms and conditions of the lease agreement itself. In this regard, the applicant may refer to clause 13 of the lease agreement, wherein it is clearly stated that any change in ownership or possession occurred by succession or by transfer to a government.
Where is the copy of the lease?
Malad, here we have not annexed because Malad, it was annexed in the earlier round. Here we have not annexed because we are on a very short premise. We are only challenging the order passed by them.
Please, Your Lordship, the lease agreements is attached with the additional affidavit, Lordship. Page number 25.
Okay. So we'll go to that. See. But it was incumbent upon you. See, you are trying to make out a case.
Right.
So you have to prove your bona fide.
My lord, here we are only saying this order itself cannot stand in view of the fact, my lord, my lord, I'll take your lordship to the entire order. Basically, what they are trying to say is this particular land is a forest land. Now, in view of the bar under section 4 of the forest land, this land cannot be given to anybody. That is their contention. And exactly on that premise, this order came to be passed. Okay. Now, may kindly see, lordship, I'll cut short my argument. I'll take your lordship to section 4 of the forest land. For Indian Forest Act 1927. Now, whenever it has been decided,
yes,
let me kindly see section 4. Whenever it has been decided to constitute any land a reserve forest, the state government shall issue a notification in the official gazette. A. Declaring that it has been decided to constitute such land a reserve forest. Now, in their pleadings, my lord, in their affidavit in opposition, there is no such notification annexed whereby they seek to declare the particular land as a reserve forest. Now, the additional affidavit which I had filed, my lord.
Yes.
where they say that it is a forest land, therefore it cannot be given to any private individual any further. My lord, but the additional affidavit and the annexures enclosed in my additional affidavit will speak otherwise. My lord, may kindly have the additional affidavit, which was filed first October 2019. My lord. Where is that thing here? Yes, that is where?
Yes.
Oh, yeah. My lord, I'll take your lordship to page 40. Of the additional affidavit.
Page
40, ma'am.
Annexure 2.
Page 40 of the additional affidavit, ma'am.
Yes.
It is a letter of April 2016, ma'am, by the Divisional Forest Officer to the Additional Principal Chief Conservator of Forest. Now, what it says is, joint inspection of the leased land belonging to the Forest and Environment Department. In referring to the above, I am to inform you that the undersigned has fixed the date for joint inspection of the leased land at Short Round Protected Forest. It's not a reserve forest, my lord. They themselves, on their own saying, they declare it as protected forest and not a reserve forest. And there's a distinction between forest, protected forest and reserve forest. On 20th
Where is that
April,
distinction made
my
out?
lord, protected forest, lordship will find at my lord, section 29.
Section 29.
Right.
What does it say?
Normally, it says that the state government may, by notification in the official gazette, declare the provision of this chapter applicable to any forest land or wetland which is not included in the reserve forest, but which is the property of government or over which the government has proprietary right, and to the whole or any part of the forest produce of which the government is entitled. The forest land and wasteland comprised in such notifications shall be called a protected forest. Number 3, my lord, no such notification shall be made unless the nature and extent of the rights of government and of private person in or around the forest land or wasteland comprised therein have been inquired into and recorded at a survey or settlement, and in such other manner as the state government thinks sufficient. Every such record shall be presumed to be correct until the contrary is proved. No, my lord, by this provision, my lord, it is clear that in a protected forest, the right of settlement exists, even of a private individual, and that's exactly the case here, my lord. That settlement was provided by the government to us in view of Section 29. Now, what they are now seeking to say, trying to, my lord, project a case is that it's not a case of Section 29, it's a case of Section 4, where a settlement is not, my lord, permissible. So, my lord, what has happened? I'll take your lordship to page 40 again. My lord, may kindly see page 41. And this is a document borne out from their own record.
Yes.
Now, my lord, here there are a number of individuals, my lord, who are similarly situated like me, like the petitioner herein, and who has a land in the same area in and around the vicinity of my plot. Now, in this case, my lord, the government very, my lord, discreetly, my lord, not only issues them the lease agreement, extend the lease agreement, they even allow the sale deed too. Sale deed too, my lord, to be executed for the purpose of transferring the land to the other side. Now, in my case, they are not extending the land saying that it's a forest land, more so of reserve forest. Now, if your lordship is aware, I have already taken your lordship to the relevant provision. If at all it is to be a forest reserve area, and they have to show the notification by which that particular area has been declared as a reserve forest. Insofar as protected forest is concerned, my lord, that right is there for settlement. So, by virtue of section 29, my lord, I am there. Now, my lord, kindly see, my lord, may kindly see paragraph, column number 2. The original lease was, my lord, I'll take your lordship to paragraph 3, my lord. Serial number 3. Sri Priyadhar Bardoloi. My lord, he was the original lessee. Now the present occupant is Motibor Kharkrang. And how the land got transferred to Motibor Kharkrang, my lord? By way of a sale deed. Now, if it is a forest land, my lord, how can a sale deed be allowed without the permission? Whether they have the approval, and this is all by way of a registered sale deed, my lord. And I'll take your lordship to other example, my lord, at serial number 5. This is Shri Bandhuram Das, was the original lessee. It got transferred to Melina Lingdaw, and that again by way of a sale deed. Now, lordship, there are numerous examples. Then, my lord, serial number 10, I am at serial number 9, my lord. Then serial number 10, Jadav Chandra Medhi.
Yes.
It got transferred to Darita Margaret Swen by way of a sale deed as early as in 1985.
Serial number 9.
Yes, my lord. 10.
10.
Then again, my lord, at serial number 11, Sri Kalpa Kanta Hazarika. It got transferred to Mondarlin Tham by way of a sale deed in the year 1996. Again, Uday Chandra Das, Srimati, got transferred to Trinsibon Lingwa, and now it stands in the name of Duintina Lingwa, sale deed in the year 1983. Again, my lord, Damodar Goswami at page 14, serial number 14, Angela Mary Kharsanthu, sale deed as early as in 2011. Now, my lord, again, at page 16, Bhavya Kanta Saikya got transferred to Lucy Mary Khongwir by way of a sale deed in the year 1973. Now, lordship, I am here with a very limited grievance. My lord, if at all you are saying that it's a forest land, two things you have to show. First, you have to show that there is a notification declaring that particular area as a reserve forest under section 4, which they have not annexed or they have not enclosed in their affidavit in opposition. Number 2, my lord, if at all it is a reserve forest, they have to explain how this land were transferred to the other occupants in the area and what action did they take, or under what premise this seal deed were allowed to be executed whereby the land were transferred. In the absence of any reasoning given by them, or in the absence of any plausible clarification coming from their end, my lord, this order will stand in violation of not only Article 14 but also under Article 300A. So I am only, my lord, with a very limited grievance, my lord, this order, in view of the documents that I have annexed and in view of the fact that there is no section 4 notification, my lord, and also considering the fact that my representation still stands pending consideration before the competent authority, this order has is not tenable in law, and therefore it needs to be set aside and quashed.
But your representation was rejected.
No, my lord. In the earlier round, my lord, they say that it is still pending.
My lord, representation was considered and rejected. My lord.
That page,
There was a very detailed order which was
page
passed.
21. Was it page 21? Where is that order?
That order starts from 22.
22 of the main reputation.
22.
It starts from 22. It's a long order till 22 to 32. It's a very detailed representation. And there was a hearing also, madam, which is enclosed at page 33. Personal hearing was also given, madam.
A hearing was given, but that's what I'm saying, my lord. Hearing was given, but this order came to be passed in a complete wrong premise.
No, madam.
Anyway, that is
correct.
that is okay.
I will show it.
That is okay. The fact remains that by order of this court, you have been allowed to
Allowed
file
the hearing, my lord.
Eventually, your representation was rejected. Therefore, you had now come before this court against the decision of
the respondent, my lord.
made as regard your representation.
Right. Madam, may kindly see of the additional affidavit. Lordship, may kindly see what is this page? 39. Sorry, page 38.
Page
38.
Page 38.
Yeah. Yes, my lord.
There's no page 38 here.
No, additional affidavit, my lord.
Additional. Oh, sorry. Yes.
Yes. My lord, may kindly see this is dated 15th of September 1998.
Yes.
My lord, plot number 9 at Short Round Forest, Shillong, petition number 7/8/1998. With reference to your petition above, I am including, this is by the Divisional Forest Officer, my lord, to the petitioner herein. I am including here with a Xerox copy of lease agreement plot number so-and-so at so-and-so, which has been leased out on so-and-so as desired by you. Please note that the lease agreement has already expired and the same is lying with the government for further action. And this is in reply to my petition for extension, my lord. So this will go on to show that, my lord, the application which I had filed is still pending consideration with the government. And there's been no order pursuant to this particular letter, my lord. That is why I went on to say, my lord, my application has not been rejected till date and it is still lying consideration. So, my lord, I sum up by saying, my lord, here, my lord, if you were to treat me in a manner in which you have been treating me, my lord, you have to, my lord, the rule of law has to prevail. Now, in one breath, you are saying, my lord, I cannot extend your lease agreement for the reason that it's a reserve forest. And in other hand, my lord, you go on to rampantly go on to allow the sale happen and also allow lease agreement, issue lease agreement to that effect to the present occupant. My lord, this is nothing but a blatant violation of Article 14. And my lord, like I said, if at all they say that it's a reserve forest, they have to show that there is a relevant notification to that effect in terms of Section 4, which in my humble and respectful submission is not there. So I therefore pray, my lord, this particular order is there passed, my lord, rejecting my representation for extension of lease agreement is unsustainable, my lord, and not only unsustainable, but is arbitrary and illegal, and therefore it needs to be quashed and set aside.
So, you are making a common submission as far as...
Yes, my lord. Item 3, my lord, they are appearing.
Accommodation as senior counsel is in argue on the next day.
Okay.
So, my lord, may I firstly, my lord, take my lords to the additional affidavit, page 25, where we have the typed copy of the lease agreement, my lord.
Page?
My lord, the typed copy starts from page 25 of the additional affidavit, my lord.
Yes.
So, my lord, may I take to page 26, my lord's attention to page 26, clause 10, my lord.
Yes.
That should the land leased or any portion thereof be at any time required for purposes declared by the government to be a public purpose, the divisional forest officer or any person authorized by him in that behalf. This is some typographical error, nevertheless, my lord. May give the lease 3 calendar months notice and writing thereof, and on expiry of such period of this lease, and the tenancy hereby granted shall be terminated. So the power already is there with the government, my lord, but without prejudice to any remedy or right of action that may have accrued to government in respect of any breach of any of the conditions herein contained, either as to the whole or such portion as aforesaid as the case may be, and the divisional forest officer so and so may enter upon the said land or such portion of the aforesaid and resume possession thereof. So there is already a clause for resumption of the land below. Thereof from all encumbrances granted thereon, and of all the buildings and erections thereon, to the absolute inclusion of the lease. The lessee shall thereupon, if a part only of the said land be resumed, be entitled to a deduction in the rent payable under this lease proportionate to the area taken by the government, provided that if on account of resumption by the government any portion of the land and the lease finds it inconvenient to remain in the possession of the remaining portion thereof, the whole of the land with building shall, if the lease so desired, be resumed. Now, this is regarding compensation for crops and all that, my lord. Then clause 11, that the lessee shall not sublet, mortgage or otherwise transfer the holding of any. So there is a clear declaration, my lord. This is already contained in this agreement, that the lessee shall not sublet, mortgage or otherwise transfer the holding of any portion thereof without obtaining the previous sanction of the provincial government or any officer to be nominated by the government for that purposes. The lessee shall not, without the previous consent in writing of the DFO, Division Forest Officer, East Khasi Hills, carry on or permit to be carried on any trade of business of the land leased or permitted, the building erected to be used for occupied in any other manner that a private dwelling house. Number 13, my lord, that when any changes in ownership or possession occur by succession or by transfer to a government servant, the person becoming entitled to be such succession or transfer shall, within 2 months from the date thereof, give notice in writing to the DFO, Khasi and Jantia Hills of such succession or transfer. So, my lord, no such information was ever given to the government. That clause 17, my lord, that on expiry of this lease, which is at page 28.
Yes.
that on expiry of this lease, the lessee shall have the first offer of renewal thereof on such terms and conditions as the government may, my lord, not shall, may or scribed some typographical error, my
May
lord.
prescribe most probably.
Yes, my lord. For the time being, and that if such offer is not accepted within such reasonable time as may be prescribed, then the interest of the lessor and the interest of one holding through or under the lessee as tenant, mortgage, or otherwise shall absolutely ceases. So, my lord, this will all automatically cease. Then in such case, the government shall have the right to resume the land. This is the exact case. We have sent notice to them for resumption. My lord will kindly see. The rights of the parties are clearly laid down here. Then in such cases, the government shall have the right to resume the land and take over all or any of the buildings standing thereon, paying to the lessee the actual value of such buildings, the value being determined by the DFO, subject to an appeal to the provincial government. So where you can appeal, that is also stated, my lord. In the case of buildings not taken over, as above, the lessee shall have the option of dismantling the same and removing the materials thereof within reasonable time to be fixed by divisional forest officer. Should any question arises touching or concerning the lease or in any covenant clause or matter therein contained or dealt with, the same shall be referred to the divisional forest officer. He has the jurisdiction, my lord, and his opinion and decision thereon. Subject to the appeal, where you can appeal, my lord, conservator of forest and the provincial government, and in the event of any appeal being preferred, the final opinion and decision of the said appellate authority shall be final and conclusive on the parties of the lease. So, my lord will kindly see there is a clear clause of resumption of the land. There is a clear clause saying that in the event the lease is not extended, then obviously the government can take over or resume the land. My lord will kindly see. Now here is a very interesting fact, my lord. In the garb of power of attorney, my lord, this is actually a transfer. My respectful submission would be, my lord, this is some kind of a Benami transfer, my lord. My lord will kindly see who is. They are just using the face of Debjani Devi, but the person who is in occupation of the land is some other person. My lord will kindly see. If I take my lord's attention to the general power of attorney, that is page 17, my lord, of the additional affidavit.
17,
17, 17, my lord.
17.
17 of the additional affidavit, annexure 1.
Yes.
So, my lord will kindly see when is this power of attorney executed and where is it executed. Now, clearly, my lord, when the power of attorney is executed, my lord will kindly see she is a nobody to the property. Lease has already expired. You have assuming that you have filed an application before the concerned authority for renewal of the lease. Your lease is not renewed. But what you do, that happened way back in 89. This power of attorney is executed in the year 2011. So under what authority? Who are you? First you will have to establish your right. Where is your right? So my lord, no all men, I take my lord to the power of attorney. By this power of attorney, Srimati Debjani Devi, wife of late Khargeshwar Sharma, aged about 81 years, permanent resident of plot number 9, short round notes forest so and so, resident of Bijoynagar, Kamrup, Assam, do hereby nominate, constitute and appoint Srimati Santosh Bajaj, aged about 60 years. So the person who is in occupation is some other person. This is some sort of Benami transaction in the garb of a power of attorney. Resident of Police Bazar, Shillong, East Castle District, Meghalaya, as my true and lawful attorney to act for and on my behalf. My lord, even assuming, even if you have to execute a power of attorney, you have to have a right. There has to be a source. Where is the source? The lease has already expired way back in 89 if I'm not mistaken. 88. You have filed an application for renewal. There was no renewal whatsoever. So what gives you the authority to execute a power of attorney? Even to execute a power of attorney, you have to have a right. Where is the right? The person also who's entered into the power of attorney,
Yes.
where is the right? My friend had...
So the lessee is not, she was not staying there.
No, she was not staying there. My lord will kindly see. It is executed in Assam. She is just the face, my lord. It is someone else who is staying there. So the notice for resumption of the land also went to some other person, my lord. Went to this particular person. My lord, we have filed an affidavit in opposition. My lord kindly refers to page 29 of our affidavit in opposition.
Yes.
So my lord will kindly see, this is plot number 9.
Yes.
Now notice is issued to Sri Santosh Bajaj.
You're referring to?
My lord, page 29 of our affidavit in opposition, which is filed in WBC number 423 of 2019.
Yes. Page 29. Page?
My lord, page 29 is the last page, which is for plot number 9.
Okay. The letter dated 13 June.
13 June 2019.
I think this was referred by...
Yes.
Tava.
So this, my lord, you are hereby, if I am allowed to read, my lord, you are hereby informed that the lease pertaining to this plot of land was granted to so-and-so by government order dated 24/8/1950, and the lease was extended by government order number so-and-so dated 4th July 1977. The aforestated lease had thus expired on 31st December 1988. 2 consecutive notices were issued. So my lord will kindly see, this is not the first notice. 2 notices were issued. 2 consecutive notices were issued in this regard by the DFO dated 29 July 1987. So it's not a case. My lord, he is saying the renewal is pending. We have, whereas on the contrary, you have already issued notices for resumption of the land, my lord, so that they vacate the premise. 29 July 1987 because the lease has already expired. Yes, 2 consecutive notices were issued in this regard by DFO. One is dated 29 July 1987 and the other is dated 26 May 1988. Respectively calling upon the then lessee holder to vacate the premise. Similarly, this is a clear notice to vacate the premise. Since government wanted to resume the said plot, the decision of the government to resume the said plot. Yes, and in fact, one of the notices, my lord will kindly see, both the notices were issued prior to the expiry of the lease. Yes, the aforestated lease had thus expired on 31st December 1988, whereas these notices were issued prior to that, my lord, for resumption. So my lord will kindly see.
So this is the letter dated 29 July.
Yes, 29 July, and one was May and one was July. Okay. One was July 87, on more than prior to a year. More
These
than
are
a year.
Notices for resumption?
Yes, these were earlier notices. So this is a known fact that this land would not be renewed. Because before even expiry also, prior to the expiry, notices were already issued. saying that government has made a decision to resume the land. And my lord, I take my lord's attention to I take my lord's attention to page 17 to make it clear. Page 17 of our affidavit in opposition. This is a clear indication, my lord.
This letter dated 12th February.
My lord, this is letter dated 12 February 1985. This is even earlier, my lord. Resumption of government forest land allotted on lease to private persons. If I am permitted to read, my lord.
Yes.
Whereas some forest land was allotted in the past on lease to private persons for purpose of construction of residential houses or other purposes, as the case may be, the Governor of Meghalaya is pleased to issue order to the effect that on expiry of lease, so indication is very clear, my lord, there is no ambiguity. The land will be resumed by the government unless the lease is extended on genuine grounds, and that sale or transfer of the land or other persons will not be allowed hereafter. So my lord will kindly see, there is a clear warning that no such sale or transfer will be allowed thereafter. Any structure or investment made during the tenure of lease will be duly compensated, paid for after proper evaluation by the competent authorities. So this is issued way back in 1985. Anyone buying such this is a very strict warning, my lord. Anyone buying such forest land on lease will be doing so at their own risk, because forest department will not agree to transfer of the lease or recognize the sale deed. This is a clear indication. So this will be the fate of all the occupants, not just one, my lord.
Yes.
The chief conservator of forest, deputy conservator of forest must maintain clear records for such forest land given on lease with details of the area, so and so, my lord. Now, my lord, may I take my lord's notice, my lord's attention to Annexure 2, page 18.
Yes.
So this is already written to, my lord, this notice is addressed to the owner, my lord, at that point, the lessee, K. Sharma, plot number 9.
This is letter dated?
This is letter dated, my lord, this 29 July 1987, my lord. This is the last page.
29 July 1987?
Yes, 29 July 1987, the reference of which is also, my lord, found in page 29.
Your copy is not clear.
Yes, my lord, I admit that, but my apologies for that. So, my lord, here also there is a clear intimation, my lord, to the lessee that for resumption of the land. In pursuance with, if I am permitted to read, my lord, in pursuance with the above government order, you are hereby informed that the land leased out to you at so and so area, short round forest, wide government order so and so, will be resumed by the government. So this is already, intimation is clearly given prior to the expiry of the lease. Resumed by the government immediately on expiry of the lease period, with effect from 1st January 1989-92. The lease expires on 31/12/1988 and 92. So here in this case, it's oblique because some lease were till 92, my lord, some lease were till 88. So that's why we have this oblique 1988, oblique 92, my lord. Since the lease will not be extended anymore, this is a very clear indication, my lord. The structures or investments made during the tenure of the lease will be duly compensated. So they never went ahead for compensation, my lord. Paid as evaluation worked out by this office, and the same may please be seen in the office of the undersigned. you are also required to my lord, intimate, probably perhaps it's intimate, my lord, to this office in writing the names of the persons presently occupying your houses on the leased land and your relationship with those occupants. Please treat this notice as final, and in the event of your failure to respond, it will be presumed that you have agreed to the government valuation of the structure, building, perhaps it's existing, my lord, on the land leased to you, and the same will be resumed by the government after necessary payment of the evaluated cost on expiry of lease period as indicated in the foregoing paragraph. So, my lord, they never went forward saying that, okay, this is my valuation, kindly. So that episode is also over, my lord. In the next page, annexure 3 is the again another notice, my lord. This is again resumption of forest land on lease to private person. So same
This
thing.
is not okay, but this is not connected to the petitioner.
No, but here it is, because that plot number 9 is mentioned, my lord.
Plot number 9.
All leaseholders, my lord, this is a general notice to all leaseholders, as well as it is addressed to K. Sharma, plot number 9.
Okay, okay.
It is 1 to 16 and plot number 9.
Is
So resumption of forest land on lease.
petitioner's husband.
Yes, my lord. So all these were addressed to him.
Yes.
So kindly see, my lord, after the expiry of the lease, everything extinguished. There is no light. Government had given an opportunity that, okay, that whoever is staying, residing in your plot, you please come and explain what is your relation with them, what is the valuation of a property, government is ready to pay compensation. So all that was never done. On the contrary, my lord, there is a lease, there is a general power of attorney executed in the year 2011, when I am a nobody to the property. I don't have any right at all. Now, as far the notices were concerned, my lord, my friend had made a statement that, my lord, there are other leaseholders which are in occupation, and he, my lord, took us to page 41 of his additional affidavit. My lord, these are simply the particulars of the people who need to vacate the land. So this is simply how.
Where is it indicated?
My lord, that was indicated in page 41, my lord.
Yeah,
The
41,
statement.
but nothing is there to say that they
My
are.
lord, to substantiate date, I will substantiate that, my lord. I will take I will take to serial number 9, page 42, serial number 9. So, my lord, will be clear that these are merely the particulars.
Serial 9.
Page 23 authors of our account after. These are all.
Okay.
As your note comes as
Yes.
as number 2.
My lord will kindly see. This is plot number 9.
See, this is just a. See, this is just a.
This is just particulars.
This is a list of
List of the occupants, my lord.
Yes,
Private occupants.
Yes, private occupants.
Yes.
So
this is simply the particular. Why I will tell you, my lord. My lord kindly takes a glance at at serial number 9, page 42.
yes,
Because here the
this refers to the husband of the petitioner.
yes,
Okay, so it refers to the land in question.
these are simply particulars. My lord will kindly see. I'll take my lord to the heading. Heading is name of the original lessee, which is at page 41. So these are mere particulars. My friend cannot constitute otherwise. Then present
nothing is
occupant.
indicated here.
So my lord, here,
Part of their letter only.
my
This is a
lord,
part of the letter which is at page 40.
exactly part of the letter means.
What I'm basically trying to show, my lord, by way of this annexure.
No. These are all illegal occupants, my lord. These are the particulars. My lord will kindly.
But
Let me finish,
No, you see, if I understand correctly,
my lord.
this page 40 here is the request for joint inspection.
of all the land.
So joint inspection of all the land and the land have been indicated in this statement.
Now, my lord, this
Nothing-
is
see, it doesn't prove anything.
doesn't prove anything.
No, what it proves is, my lord, here in one hand you are saying that resumption will not extend the lease. In other hand, you are allowing even the sale to happen.
No. That,
No, where is have
My lord,
anyone?
my lord, it is their
My lord,
own
has
document.
has my
The
friend
original
brought, no,
lessee-
please wait.
Please, the court
Has
is
my
asking
friend
me a
bought-
query. I'm clarifying that.
No, not that.
My lord, may kindly see the name of original lessee and the present
I
occupant.
understand what you're trying to say.
Yes, ma'am.
Has my friend brought anything on record which shows that there is a permission given by the government, by the forest department? Please let him bring on report, my lord. There is nothing on record. This is all done.
without
Please
the
let me
permission of the
submit.
government.
No. Please let me finish. This is all done behind the back of the government, my lord,
Oh,
without
see,
the knowledge of the government.
Mr. Bhattacharya, look at the, for example, look at the serial number 3. The last column remarks
Yes.
transferred by government letter so and so.
1983. My lord will
Yeah,
kindly see. Lease were
exactly.
expired in 1988 and 1992. This is a letter of 1983.
Exactly.
My lord will kindly.
So
My lord will kindly see. Lease are expired in 88. What is my friend saying?
As on 1983, the lease is still subsisting.
Yes.
It may have been transferred, it may have been sold, whatever.
Exactly.
That is a different issue altogether. But the fact remains that as
What
on
happens to the letter which he
yeah,
referred to
as
of
on
1980?
2000 as
where
on
they
2000 see, as on 2016, these are the names of the occupants.
These are the names of the occupants.
Now, my lord, what happens to the letter which he had just referred of 1980, where they say sale is not permissible?
Oh, that you have not brought that.
No, he has brought. He read his affidavit where he has categorically referred to that letter by the government saying that the sale is not allowed. In one hand, in the year 1980, you say sale will not be allowed, and in 1983, you grant permission.
Where is the permission? Please show us the
My
permission.
lord, may kindly see transferred by government letter number so and so.
My lord, this is
In the year
1983. Why is my friend trying to confuse this
My
honorable
lord,
court?
what I'm saying is
1983
you
and
write,
1988.
my lord, 1980 you write a letter saying that no land will be allowed to be sold by way of a sale deed or any form of transfer. That is in the year 1980.
But you see, that doesn't prove. Again, I'm
No, I'm not.
again, what
I'm
trying
not
to
on
say-
proving anything.
Yeah, that's what
I'm
I'm
only
trying to
saying,
say
my
is that,
lord, if at all they
we are
take
not
any
talk-
action,
we are not
it has to
talking-
be in consonance with Article 14.
we are not talking here about
This is a question of forest land.
we are not talking here about the character of the lease. What we are talking here is the action of the government. Firstly, to resume the land, and for resumption of the land, joint inspection was conducted or sought to be conducted by that page 40, and these are the
Yes.
notice was issued to all of
Exactly.
you.
My lord,
All 9.
my lord, that is why exactly why at serial number 9, the
So see, then
the
you cannot make out from here.
No.
What will be what is the ultimate decision?
No,
Because
the only
that will come
reason why
later.
I brought this document on record, my lord, is to show that there is no parity of action, my lord.
That is a
no,
different
no.
thing.
That
That
is
is a
incorrect, my
different
lord.
There
is
is,
nothing
there
on
is no
record.
parity of action. Here, my lord, some people have been picked and
What-
choose.
See, Mr. Thapa,
There is nothing
Mr.
to
Thapa,
substantiate, my
what
lord.
you could have done is this. To strengthen your case, you could have said that let's refer to this list. This list of how many of 16.
Altogether, my lord, there are 16.
16. So in this list of 16, you have been singled out. You and maybe one or two who have you have been singled out for resumption. Whereas the rest of these people in the list, no notice has been issued to them.
That is correct, my lord.
If you say that, then we will look into the purpose of the government as to why resumption is required only
in my case. There has to be a particular ground given, my lord.
My lord,
That is exactly my case, my lord.
My lord, to corroborate or support my submission, my lord, I take again my lord's attention to our affidavit, which is filed, page 20. Now, in the general notice, my lord will kindly see in the general notice, it says serial number 1 to 16.
Yes.
Resumption, notice for resumption is given to all.
Exactly. That's what I want to know.
My friend is completely misleading this honorable court.
No, it is a query of the court. So
Yes, my lord.
Maybe he has said it in his in his petition or not. That remains to be seen. He may not have. you're just
My lord,
refer
this
again
is
to page
annexure
number.
3, page 20 of the affidavit in opposition that we have filed, my lord.
Yes. So all leaseholders.
Yes, all leaseholders. My lord, serial number 1 to 16. This list also serial number 1 to 16.
So there was, you see, it was not a question of you being singled out.
No.
My lord, may kindly see if that is the case, whether they have at all proceeded further after that. My lord, it's
My lord,
okay. My
it
lord, we
has
have
to
come
proceed.
before your lordship.
It has to
They
proceed.
may have a reason to say that we did not proceed because the matter is pending. But in respect of others, there is no writ petition pending, my lord. What action have they taken so far? To prove their bona
Petitioner
fides,
has
let them
to-
show, my lord, what have they done so far.
Petitioner has to stand on her
No,
own
I'm
footing,
not
my lord.
saying that, my lord.
She
If
cannot
you are,
say that
since
what
we
the
both
government
of
has
us
done
are,
with others and
since
not.
we both of us are here before the honorable court, in a writ court, my lord, the conduct or the actions, if at all they take, has to be in consonance with law, my lord. It has to.
It
The
is
rule of
absolutely
law
in
has to be
consonance with
prevailed.
law.
Like as lordship has
Where
rightly
is
said,
the...
my own entire case here is, my lord, I've been singled out. Me and the other petitioners.
You can press that contention.
But there
You
is
can
nothing to
substantiate your
substantiate, my lord.
contention. He will do likewise, and it will be for the court to weigh and
Correct, my
balance.
lord. Let
and
them
see
show, my
is-
lord, what action they have taken so far. I don't think, my lord, they have
No,
taken anything.
it is not.
Because, my lord, why I'm
petitioner
saying that
has
they
to
have not
stand on her
taken
own
any
footing, my
action.
lord.
My lord, it is off the record. I'm making a statement, my lord. Why they have not taken any action as against the other occupant? There are few of them are, my lord, people from the very, my lord, domain within the government. Some of them are there. I mean, the people within who have very close connections with the government are there. That is why, my lord, that is why I'm saying, my lord, we have been singled out. That is why we are saying, my lord, we have been singled out. And insofar as the other occupants are concerned, government will not take any action and has not taken any action.
My lord, these kind of
Let
submissions...
them show, my lord, what actions they have taken insofar as others are concerned.
No, why?
If they are
My lord,
saying that,
we are not
if they are
duty-bound,
saying,
my
my lord, they have acted in,
My lord, the very fact that
consonance with
notice...
Article 14, let them
My
show.
lord, the very fact that notice is issued to all.
Even if you consider the issue, see, of arbitrariness, then everything has to be taken.
Absolutely, my lord.
My lord will kindly see. Lease was executed. I am giving a brief history. Lease executed. It was renewal was done once. Prior to the expiry of the lease in 1988, notices were already given that government has the intention to resume the land. There will be no extension of the lease. So once the lease is expired, where is the right? When you approach this honorable court, you have to establish that you have a right. Where is your right? There has to be some source. Wait, let me finish. Then you continue. If you approach this honorable court, my lord, you have to explain how you have the right. Where is your right? Whatever right was there has already been extinguished after the expiry of the lease. Nothing remains in existence. Where is the right? And then you go ahead and execute a power of attorney in the year 2011. You see, my lord will kindly see, look into the intentions of the parties. How? What is the basis? It cannot be permitted. Now,
by 2011, the lease has expired.
My lord, lease expired in 1988. 1988, my lord. So, my lord, when is the power of attorney executed? 2011. 88, 98, 2008. So, my lord, more than 20 years, 23, let's say 23 years, my lord. More than 2 decades, power of attorney is executed. And you want to establish your right. How can it be?
Well, we kindly appreciate one thing. I'm still I'm in a jurisdictional.
My
jurisdictional
friend may
possession
allow
of
me
the
to
property.
submit. Then whatever rebuttal he can give thereafter. Now, even
I think, Mr. Sir,
yes, my lord.
we'll continue on the next date.
My lord.
Heard Mr. Estapal, counsel for the petitioner. Also heard Mr. counsel for the Alanet G, appearing for state respondent. Hearing is not concluded and will continue on the next date fix. How long? 1 week?
1 week, my lord.
This is matter to, as prayed for, this is matter to 1 week for further hearing.
All right, my lord.
All right.
Item number 4.
What is the petitioner?
Lordship, our apologies, my lord. The meeting could not be held on the last date due to some unforeseen circumstances. So the next meeting is scheduled to be held on the 21st of August, Lordship.
Has any is this the first meeting or any sitting has been conducted?
With the government, it will be the first, my lord.
With the,
Lordship.
nothing has come out of it.
No, my lord. The meeting has not taken place at all, Lordship.
A while ago,
Lordship,
your colleague has suggested that this matter may be, referred for mediation.
Lordship.
What do you say?
We have no mediation.
We have no objection to it. There.
Because you see, from what I understand,
No.
the meeting that is scheduled to be held between the parties have not.
No, it has not taken
It
place.
has not taken place.
Those are my instructions.
That's
On
what-
the 25th also it will
that's
take
what I
place,
said.
and on the 4th of July also it did not
Next
take place.
meeting is scheduled at on
21st August, Lordship.
21st.
Lordship.
No, 21st of August again.
But in the meantime, the alternatively, as I was saying,
My lord.
Mrs. Yangi has suggested that this matter may be referred for mediation.
That could be done, my lord.
What do you say?
My lord, we are having a slight difficulty, Lordship, if only we could sit for the 21st of August, Lordship.
It depends. Of
My
course.
lord.
You see, because either we go for mediation or you decide to
My
sit.
lord, my
you know,
lord.
you sit across the table just between the
Lordship.
parties. It makes no difference.
We
because
would prefer the
eventually it will
21st
come to
August
that.
meeting, Lordship.
That's all right, my lord, because if mediation, all the parties must come to a consensus. Then only matter can be referred.
Because in mediation, a mediator will be appointed,
My lord.
and then he or she will conduct the proceedings. But otherwise, if both of you, or rather both the parties, sit across the table and discuss, nothing like it.
Lordship.
You know, we are open to both options, subject to what my friend has to say.
But at least make sure that something is,
Lordship.
You know,
My lord.
materialized. Otherwise, we cannot just keep, matters on hold.
Yes.
My lord.
Miss Jishla Larat, Senior GA, appearing for the state respondent, has submitted that the meeting, which was supposed to be held between the parties on 25/7/2025, could not be held due to unforeseen circumstances. However, another round of, the same has been rescheduled to 21/8/2025. As such, it is prayed that some time may be allowed for the parties to sit together and discuss the issues involved. Mr. K.C. Gautam, counsel for the petitioner, has no objection to the and is agreeable to the meeting scheduled to be held on 21 and is agreeable to participate in the meeting scheduled to be held on 22. Accordingly, as prayed for with the parties, list this matter up to
Last week, my
this
lord.
is matter on 28.
28.
Much obliged, Lordship.
Obliged.
Item number 5.
See, Mr. General,
Yes,
again,
same problem. Next date, another date.
next week then.
Monday or Tuesday, subject or convenient.
It depends. Monday, when is Monday? 25th or 18th?
18th.
Apa week no? Week apa ni tak kendai? Huh? Nah, okay, no.
You might not fix it as a top of the list since my friend will give a reply only.
Top of the list. As agreed to by the parties, list is matter for the hearing on 18. So she'll make a mental note of it.
Very good.
Top of the list.
All right.
Very good.
May I please, Your Lordship? Your Lordship, I beg to mention item number 12 on behalf of Jaishalla.
On premier by the appellant, this is matter after 3 weeks.
Similar prayer for item number 13 and 14, Your Lordship.
Same counsel.
Same concept.
13.
13 and 14.
14.
Same order. Jo.
Oblige, Your Lordship.
Lordship, I beg to mention item number 16. Yes.
This matter was heard.
No, Your Lordship.
So I can do on premier by. This is matter after 2 weeks.
Lordship, I beg to mention item number 9 of the main list, Lordship. Lordship, I'm praying if this matter can be taken up after 2 weeks, Lordship.
I think we have made it clear that no adjournment in this matter.
Lordship, the difficulty is that Lordship, Learned Senior today has gone for inspection, Lordship, with regards to the matter which is pending before the division bench, PL trees, Lordship, along with the Advocate General of this on foot, Lordship. So,
On pre-meet by the respondent, this is matter after 1 week.
Lordship, hello.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 17, Your Lordship. Lordship, I humbly pray if this matter may be taken after 2 weeks, Lordship. It's a joint prayer, Lordship.
On pre-meet by the petitioner, by Ms. Kigurmo, the counsel for the petitioner, that is adjourned. This is after 2 weeks.
Much Lordship.
Chief, I beg to mention item number 8, Lord Chief. Because in item number 7, Lord Chief.
Hey, Mr. Sheikh.
Yes, Lord Chief.
This one related.
Yes, item number 7 has already argued, Lord
Already
Chief.
heard.
Yes, already done. So what I pray, Lord Chief, on
Only to submit
written argument. What I pray, Lord Chief, on the next day, if that item is listed as a fixed item, Lord Chief, so that we can finish up on the same day, Lord Chief.
Once it is in the list, it's fixed.
Not Lordship, true Lordship, because that above that the part of matter are there, Lordship. Part of matter.
If it's there in the list,
yes, Lordship.
It will be taken up. But at least today, you should have.
Part of matter are there.
Because why I'm saying this? The other cases
yes,
already over. So we were thinking that, this matter also will be heard. And perhaps a common judgment may be passed.
Yes, Lordship, right on the last occasion, Lordship, because the council was, he was supposed to appear PC, Lordship, and he was waiting. In fact, our matter did not reach, Lordship, last week, Lordship. So today also he was PC, he was in BC, Lordship, because that is why, Lordship, because and above us there are 2 part matter, Lordship. It might take little time. So 1 week on the it is listed on the next week, or so that if it is that is item number 1 or 2, so that we can.
On premier by Mr. Sheikh Council for the appellate, this is matter after 1 week.
Filed a written submission within 1 week, Lordship.
Your Lordship, if you permit, we can.
You're filing?
Yes, yes.
Katha 7. Appellant has filed a written argument. However, Mr. Ichkarmi, learned additional PP, has sought for some time to file his written argument. We allow this is matter after 1 week.
Please, Your Lordship. Lordship, I beg to mention item number 15, Your Lordship. Item number 15, Your Lordship. I pray this matter may come up after 1 week, Your Lordship.
No objection. Mr. Hassan is conducting counsel in this case.
1 week, Your Lordship.
On premier appellant, this is matter after 1 week.
Oblige, Your Lordship.
Please, Your Lordship. I beg to mention item number 10. The conducting counsel is in personal difficulties. Kindly fix the matter after 2 weeks.
On prayer made by Miss the counsel of the appellant. You are for the appellant? You are counsel for the appellant?
Yes. She is.
List this matter after 2 weeks.
Deputy.
Daily list item number 1.
In item number 1, I am appearing in virtual mode. I am appearing for the respondent.
Yes.
And I pay 2 weeks further time to file my affidavit in opposition.
How many respondents are there? Only one?
Only one.
Yes,
He is not
prime.
posted at Chandigarh, could not come. Only posted at now Chandigarh, could not come.
Mr. S. Not letter counsel for the respondent has sought for time to file the counter affidavit. On premier, the same is allowed. Place this matter up to 2 weeks.
Oblige, Your Lordship.
Deeply.
Item number 2.
Mr. Nat, you are in any of these cases?
Yes, in item number 18, my lord.
Next, we'll be
Along with the item number 1.
fine. 2 weeks.
Deeply.
Please.
Lordship, the admitted fact, Your Lordship, is done. The respondent herein, Your Lordship, they are the appointees of 2008-2009, Your Lordship. Lordship, that will find Lordship at page 66 of the memo of appeal. On page 66, then 70, Your Lordship.
Just a moment. This office order.
Lordship,
66
Lordship,
is-
yes. This is the office order dated 10 September 2008, Your Lordship.
10 December or 10 September?
10 December 2008, Your Lordship. These are the name, Your Lordship. The lead respondent is Moksadul Amin Mondal.
Yes.
These are serial number 3, Your Lordship. Then another appointment, Your Lordship, that is the office.
This is the appointment order.
Lordship, yes. Then Lordship will another appointment order, Your Lordship, will find at page 70. That is the office order dated 7/1/2009.
Yes.
Lordship, they were regularized, Your Lordship. They were regularized in the year 2021. Lordship will find the order of regularization at page 78. Page 78, Your Lordship.
Yes. I think this
And-
was, you have also referred this.
Lordship,
19th
yes.
February.
Lordship, yes. Then, Lordship, then by virtue, Your Lordship, of the new pension scheme, Your Lordship, came into effect on 1/4/2010. 1/4/2010, Your Lordship. So, in view of that fact, Your Lordship, in view of that fact, Your Lordship, that the new pension scheme came into effect in 1st April 2010, Your Lordship, and then the fact that the writ petitioner respondent herein were regularized, Your Lordship, in the year 2021. So by operation, Lordship, I'll take Your Lordship to Lordship, kindly have a look at page. Lordship, I'll try to quote short my argument, Your Lordship. Lordship, the new pension scheme, Your Lordship, will find it at page 179.
Your Lordship may look from this book. That will be more easier.
179, Your Lordship. And I'm taking Your Lordship to the Appendix A at page 182, clause 3.1. 3.1.
Yes.
3.1. The scheme shall, page 182, Your Lordship.
182.
Clause 3.1.
Yes.
The scheme shall be applicable to all new entrants joining state government service on regular basis against sanctioned vacant posts on or after 1st April 2000. It shall also be applicable to all government employees whose services will be regularized against regular posts on or after 1/4/2010 with the benefit of prospective deal. So, Lordship, in the case of the repetition will be governed by this, Your Lordship. They will fall under the new pension scheme, not under the old pension scheme, Your Lordship. Lordship, this office memorandum, Your Lordship, this office memorandum will have the force of law, Your Lordship. Because, Your Lordship, if Lordship go by the Article 162 of the Constitution, Your Lordship, the exclusive power of the state, Your Lordship. Lordship, if Lordship kindly have 162. Lordship is 162, Your Lordship.
Yes.
Can you have 162? Extent of the executive power of the state. Subject to the provision of this constitution, the executive power of the state shall extend to the matter with respect to which the legislature of the state has power to make laws. Provided that in any matter with respect to which the legislature of the state and have power to make law, the executive power of the state shall be subject to unlimited by the executive power expressly conferred by the constitution or by law made by the parliament upon the union or authorities. Lordship, I kindly see, Your Lordship, the pension rules, Your Lordship, is a rule made under Article 309 of the Constitution, Your Lordship. But here, Your Lordship, there is an office memorandum. It is not this office memorandum, Your Lordship, is not made under 309, Your Lordship, but it has been issued, Your Lordship, because under 162, there is a power of the state, Your Lordship, to issue executive instruction, Your Lordship. So this office memorandum, Your Lordship, in my humble and respectful submission, Your Lordship, is a executive instruction, Your Lordship.
So executive instructions has power
It
of
will
law.
have, Lordship, yes, it will have a overriding effect on any order issued by the department, Your Lordship. Because, Your Lordship, in this case, what happened, Your Lordship, by the order of regularization, Your Lordship, there is, Lordship, kindly turn again to that order of regularization, Your Lordship, at page 78, Your Lordship.
Yeah, 2007.
Lordship, no, the order. Lordship, 70, Your Lordship, kindly have a look at page 70 again, Your Lordship.
What is
Then, Lordship, kindly come to page 79, Your Lordship. The regularization says like this, Your Lordship. The regularization is, however, subject to the following conditions stipulated by personal and AB letter dated 27/8/2007. This letter of 27/8/2007, Lordship, will find it at page 242 of the memo of appeal.
So, okay, just tell us. You mean to say that this letter of 27 August is, can be,
this will have no applicable. Lordship, what I mean to say this.
Superseded by that.
No, Your Lordship, what I mean to say this letter 27/8/2007, Your Lordship, will have no application in this case, Your Lordship, because in that order of 27/8/2007, Your Lordship, these are the ad hoc appointees regularized by the state cabinet, Your Lordship. But here in this case, Your Lordship, it has been regularized. It has been regularized by the Public Service Commission, Your Lordship, and approved by the government, Your Lordship, and approved by the government. Lordship, you got my point, Your Lordship. Approved by the government, Your Lordship.
So what we are essentially looking at, we are looking at the strength of each notification.
Lordship, yes.
Which will overpower which? According to you, this.
The executive instruction, that means the office memorandum, Your Lordship, will have overriding effect on this letter of 27/8/2007, Your Lordship. Because, Your Lordship, the office memorandum, Your Lordship, in my humble and respectful submission, Your Lordship, because because of the executive power of the state, the state has the power to issue this kind of executive instruction. So it will have an overriding effect, Your Lordship.
Yes.
Even Your Lordship, in the impugned order by the learned single judge, also, Your Lordship. Lordship, kindly come to page 257. there is an observation, Your Lordship, which the learned signature also, in my humble and respectful submission, has agreed, Your Lordship. But just because of that letter of 27/8/2007, the relief has been granted. Kindly come to page 257, Your Lordship, para 9 of the judgment.
Yes.
The guideline for implementation of the new pension scheme at clause 3.1 read as follows. The scheme shall be applicable to all new entrants joining the state government service on regular basis against sanction back and post on or after 1st April 2000. It shall also be applicable to all government employees whose services will be regularized against regular post on or after 1/4/2010 with the benefit of prospective date. No doubt this guideline has to be taken into consideration while determining the entitlement of the employees based on the date of regularization. However, as noted earlier, the letter dated 19/2/2021 regularizing the service of the petitioner on the one hand, while applying the condition as contained in the letter dated 27/8/2007, whereby the period of so and so was to be taken into consideration for the purpose of pension in the same letter itself, had inserted the impugned clause 4, denying the petitioner the benefit allowed by the letter dated 27/8/2007. This contract with Lordship. Even the learned signature also, he is in line. But just because of that letter, Your Lordship, 27/8/2007, Your Lordship, because this is the letter, Your Lordship, which had been issued by the personnel department regularizing those people, ad hoc appointees, Your Lordship, by who had been regularized by the cabinet, Your Lordship. Lordship, what does it say, that letter of regularization, Your Lordship? In clause 4, it says the 38 numbers of junior divisional accountant shall be governed by the new defined contribution pension scheme by finance number so and so. Lordship, kindly come back to page 79, clause 4. Clause 4, Your Lordship. The 38 numbers of junior divisional accountants shall be governed by the new defined contribution pension scheme by finance so and so, Your Lordship. So this clause, Your Lordship, is...
So this is the contradiction that was detected
Lordship,
by the...
yes. The contradiction, Your Lordship, that is the order of regularization will be governed by the letter dated 27/8/2007, and the contradiction is in clause 4, Your Lordship, to be governed by the new pension scheme, Your Lordship, which in my humble and respectful submission, Your Lordship, this clause 4, Your Lordship, is in tune with the new pension scheme, clause 3.1, Your Lordship. And this, Lordship, kindly also note, Your Lordship, that 3.1 clause, Your Lordship, was not a subject matter of challenge before the learned single judge, Your Lordship. So it remains, Your Lordship. It remains, as I have submitted, Your Lordship, since this is an executive instruction, that the executive instruction will have an overriding effect on this letter of 27/8/2007, Your Lordship. And as such, the fact that
Mr. Shulai,
Lordship,
I can understand. See, there is no, there was no contest as far as the, the guidelines of 3.1 is concerned.
There was no.
In itself, you see, in itself, it still hold a field.
Lordship, absolutely, Lordship, absolutely correct, Your Lordship.
As far as this case is concerned, you keep that 3.1 on one hand in juxtaposition with this 27 point, this
Lordship,
27
yes.
August.
That is
where
the contradiction.
That's
Your
where the
Lordship.
difference lies.
That is the contradiction, Your Lordship.
And that has
is
been
the contradiction, Your Lordship. So what I'm submitting, Your Lordship, since the office memorandum, that means the new pension scheme, Your Lordship, which has come into force with effect from 1/4/2010, Your Lordship, since it has been, Lordship, because it has been issued by the state in exercise of the power under Article 162 of the Constitution, so it will have a riding effect, Your Lordship, on the letter dated 27/8/2007. And the clause 4 in the same order of regularization has been rightly inserted by the competent authority, Your Lordship.
What is impugned in the writ?
Lordship, clause 4.
Clause 4.
Clause 4 only.
Clause 4 was impugned.
Clause 4 only, Your Lordship.
When was the writ filed?
The writ was filed, Your Lordship, in the year 2022, Your Lordship.
2022.
July 22, Your Lordship. Page 60 of the
So,
memo of
see,
appeal, Your Lordship.
Mr. Sulai,
Lordship.
between 19 February 2021 and July 2022, you could have made some correction here.
There lies my difficulty, Your Lordship. Lordship, I must admit, lies my difficulty.
You could have utilized.
Lordship.
What was your
Lordship
General
was
Process Act?
is absolutely correct, Your Lordship. Lies,
21, isn't it?
here, there lies my difficulty, Your Lordship.
So, if we say if the petitioners are sleeping over their rights, no relief is granted to them. If now it is on the other side, respondents are not exercising their rights, what do we do? Anyway, that is
The only thing, Your Lordship, another leg of my submission is done. That clause 3.1, Your Lordship, which is appendix A to the office, that was not never questioned, Your Lordship, in the writ petition.
no. It is
So it remains, Your Lordship. It remains, Your
It
Lordship.
is. It would
It
be.
remains, Your
It
Lordship.
would be our preliminary observation that would be that would be valid. See, that would be valid as a standalone provision. No, there was no contest as regard its validity. No virus is found. It stands. But the only thing is that when placed in the context of this notification, there lies the difference.
Then another.
What will supersede? That will have to.
Then another submission, Your Lordship, also I would advance, Your Lordship. In the order of regularization, there were 38 people, Your Lordship, and the people who filed the writ petition is only 22 people, Your Lordship, 22 person only, Your Lordship. So if Lordship is inclined to uphold the Lordship, then this benefit will only be applicable to these people who have filed the writ petition. That is all, Your Lordship.
There are laws to that effect.
Lordship, first and foremost,
Mr. Kanta, I think
I'll just take 2-3 minutes if the court permit. Just 2-3 minutes, Your Lordship. I'll not take much time if the court permits, Your Lordship.
Yes, you can.
Because first and foremost, Your Lordship want to rise?
No, please.
2-3 minutes I'll take. Your Lordship, I may draw Your Lordship's attention to Miss Case number 39 of 2025, dated 13/6/2025. The order passed by this Honorable Court.
That has been argued, Your Lordship. That has been argued, Your Lordship.
Kindly, please,
That is so see, that was on a entirely different premise.
No, I wanted to.
That is with regard to the.
I wanted to point out something else, Your Lordship.
Application of the General Process
Yes,
Act.
you wanted to withdraw that.
Yes.
Para 12, Your Lordship, may not look also. Para 12 of that order. The Learned Senior Counsel has further submitted. No, it's already in the records, Your Lordship. On the last occasion, it was submitted.
You have cited?
Yes, Your Lordship.
Okay.
The Learned Senior Counsel,
Just a moment.
Para 12, Your Lordship.
Para? Good.
Just Para 12.
Good.
Submitted
Yes, one copy each the last occasion.
Yes.
Para 12, Lordship. The Learned Senior Counsel has further submitted that by virtue of the said regulation order dated 19/2/2021, which was issued based on the Cabinet decision dated 10/1/2013, the validity of the same being confirmed by the Honorable Red Court by the judgment dated 5/4/2024, passed in WPC number so and so. Just that much, Your Lordship. I'll come to the page 78 of the Red Appeal, Your Lordship. Your Lordship, when we look at the cause title of the page 78, the reference, this department letter number FEG 62 2007 244 dated 10 Jan 2013. This document, Your Lordship, is also along with this judgment passed by this Honorable Court in this case. I've annexed it there, Your Lordship. It was right there. Now, Your Lordship will notice that by virtue of the Cabinet decision, this is referred in the page 79, copy forwarded to number 1, Cabinet Affairs Department, with reference to agenda number 103 of 2013, dated 10/1/2013. Way back in 2013, the writ petitioners were regularized. The delay was in the Department of Meghalaya Public Service Commission. It took quite some time there. Now, that is not my fault, Your Lordship. Now, Your Lordship may have a look at the new defined pension scheme, Your Lordship. I'll just read that and I'll finish. The question is whether the new defined pension scheme is applicable to ad hoc employees and those appointed under 3F. Most important, Your Lordship. Now, I'll just go through the new defined contribution pension scheme, Your Lordship, that was issued on 24th March 2010. Introduction of new defined contribution pension scheme. The salient features of the new defined contribution pension scheme are as follows. And before that, Your Lordship, the new defined contribution pension scheme, the new pension scheme comes into operation with effect from 1st April 2010 and is applicable to all new entrants to state government service joining on or after 1st April 2010.
You're reading which part?
The new defined contribution pension scheme. I'm not reading the guideline, which is Appendix A, Your Lordship.
You're reading this salient features?
Yes, Your Lordship. No, just before the salient features.
In pursuant of decision?
No, Your Lordship. Just before the salient features, I'm reading the subject part.
Okay, sorry.
Yes.
Yes, sorry.
What I'm trying to say, Your Lordship, this new defined contribution pension schemes come into effect on 1st April 2010.
Yes.
Now, by virtue of this scheme, Your Lordship, I come straight to para 4.
Yes.
I'm just cutting short. The existing provisions under defined benefit pension and GPF would not be applicable to new government employees joining government service on or after 1st April 2010. So I'm trying to stress the new entrants, Your Lordship. Now I come to Appendix A, Your Lordship. The guideline. Because there are two appendix, Appendix A and Appendix B.
Yes.
I'll just go through. 3.1 my colleague has already gone through. And I come to para 5, Your Lordship. Because the other day the Honorable Court was questioning what are the losses. Here it is, Your Lordship. Para 5, the Meghalaya Civil Service Pension Rules 1983, the Meghalaya Civil Services General Provident Fund Rules 1985 are amended from time to time, including the Assam Services Extraordinary Pension Rules 1963 adapted by the Government of Meghalaya, will not be applicable to government employees who join state government service on or after 1st April 2010. In other words, the existing schemes of pension, gratuity and general provident fund would cease for new entrants to the state government. These are the losses, Your Lordship.
Yes.
Now, para 6. Government employees who was in the state government services before 1st April 2010 but joins in new government service on direct recruitment after resignation which is in the nature of technical designation, is eligible for pension covered under the provisions of Meghalaya Civil Services Pension Rule 1983. Now, I come to Appendix B, Your Lordship. And without much ado, I come straight to Para 9, Your Lordship, of Appendix B. Check that new interns, bracket government employees, are born on sanctioned posts and that the appointment recruitment are on regular basis establishments. In other words, ad hoc or Regulation 3F appointees are excluded. Refer Para 3.1 and 3.2 of Appendix A. I read again, Your Lordship. Parani. New entrants are born on sanctioned posts and that the appointments recruitment are on regular basis establishment. In other words, ad hoc or Regulation 3F appointees are excluded. Refer Para 3.1 and 3.2 of Appendix A.
Don't you think there's contradiction here?
Pardon, Your Lordship?
Don't you think there's a contradiction? 3.1, what does it say again?
3.1, it says, the scheme shall be applicable to all new entrants joining state government service on regular basis against sanctioned vacant posts on or after 1st April 2010. It shall also be applicable to all government employees whose services will be regularized against regular posts. When we talk about regular posts, is what I have referred just now, Your Lordship. On or after 1/4/2010, with the benefit of prospective date. By virtue of this Para 9 of Appendix B, those who have been appointed under 3F are excluded, Your Lordship. So the new defined pension scheme will not operate insofar those ad hoc employees or those appointed under 3F. It is not disputed, Your Lordship, that the 38 junior divisional...
So, I think we have to qualify this term, regularize. Regularize against regular posts. What does it mean?
When we talk about...
In 3.1...
I read again 3.1, Your Lordship.
Just that part, it says...
The scheme shall be applicable to all new entrants joining state government service on regular basis against sanctioned vacant posts on or after 1st April 2010. We stop there.
Yes.
Now the second part. It shall also be applicable to all government employees whose services will be regularized against regular posts on after 1/4/2010 with the benefits of prospective date. Now we cannot read this 3.1 in isolation, Your Lordship.
Yes.
Now we have to read in conjunction with Para 9.
Para 9.
Yes, Lordship, of Annexure B, of Appendix B.
Appendix B.
Appendix B is not there in the writ appeal.
It is there in the writ appeal, Your Lordship. It is there. My colleague did not read it.
That we will find it at page 17.
No, it's okay.
It is there in the memo of appeal, Your Lordship.
That is okay.
Lordship.
You have only...
Your Lordship,
illustration. This 188. Is it 188? No.
188, Your Lordship, in the memo of appeal.
So, Mr. Krita.
the operative part will be at page... it will be at page 228.
189.
Sorry.
189.
189. Oh, yes.
No, this you see, the meaning of this para 9 has to be clearly spelled out.
When we talk about new entrance, the new define
This read with 3.1.
3.1, Your Lordship. 3.1 speaks about 3.1 speaks about new entrance.
Those who new entrants and those who were or was or are to be regularized in regular
Those new
posts,
entrants.
in regular posts
New entrance.
after
114.
after 1.4.
That's no dispute, Your Lordship. When we talk new entrants, we don't talk of those who.
But you say this, if we read para 9
Yes.
of Appendix B, it would mean to say that the word regularize in 3.1 will not apply to those who are appointees under
Before 1/4/2010, Your Lordship.
no. Those who have been initially appointed under
3F.
rule
Correct, Your
3F.
Lordship. Correct. Those who are appointed under 3F. The 22 writ petitioners, respondent herein, are appointed under 3F. It's not disputed, Your Lordship. And it is,
that is the point.
it is referred in this regularization at page 78. It is referred there also, Your Lordship. They are appointed under 3F.
Okay, for our satisfaction, can you tell us what is the mode of appointment? For example, regular appointment by the usual process, selection process of advertisement and all those things. Then ad hoc appointment, regular, then appointment under 3F. Then what else are there?
Lordship, a regular appointment means they have to compete. That means it's thrown open.
Yes, it is.
In accordance with Article 1416 of the Constitution, Your
Maybe
Lordship.
in response to an advertisement, whatever.
Then so far ad hoc, Your Lordship, this is
To non-sanctioned posts.
Lordship, I may say, Your Lordship, these are all backdoor appointment. Backdoor entrance, Your
But
Lordship.
that
Non-sanctioned posts.
but that process has already been has been
Lordship,
resorted
yes.
to.
So we are Lordship, yes.
So, if it means that, or those who are appointed under 3F are to be excluded.
Yes, Your Lordship.
Lordship, I think the contention of my friend, Your Lordship, if you say para 9, Your Lordship, it talk about new entrants. Lordship, kindly come to page 189. Check, Lordship.
Yes.
That new entrants. That means new entrants, Your Lordship, means those people who came after 1/4/2010.
Yes.
Then are born on sanctioned posts and that appointment are on regular basis establishment. In other words, ad hoc or regulation 3F appointees are excluded. Refer para 3.1 and 3.2 of Appendix A. Lordship, if go by Appendix 3.A, Your Lordship, it said it shall also be applicable to all government employees whose services will be regularized against regular posts on after 1/4/2010. So, Your Lordship, the respondent here in Your Lordship, they fall under this category, Your Lordship. Regularization after 1/4/2010, Your Lordship.
If I may be wrong,
Lordship.
What I could understand is this. See, now the new pension scheme is in place.
Lordship.
After 1st April
2010, Your Lordship.
We are not talking about those, for example, like the appellants or the petitioners who have been appointed prior to
2010
on ad hoc basis or under 3F.
Lordship, yes, correct, Your Lordship.
Now, subsequently, after the new pension scheme came into force, those who are to be appointed under ad hoc basis or 3F will be excluded from
Lordship, yes. Lordship, yes.
Perhaps that is the
Lordship, yes. Lordship, absolutely correct, Your Lordship. Absolutely correct.
This one. Yes, Mr. Kata, I think this paradigm has no relevance to your case.
It has no relevance.
Anything else?
Then in that case, I have to continue a full-fledged submission, Your Lordship. If Your Lordship is not convinced by that, Para 9, insofar 3F is excluded, then I'll have to continue.
Para 9 is basically what? Is an instruction issued to all the head of the department.
Yes, Your Lordship.
And what does it say? It simply says that to make this new pension rule applicable to the new entrants, they should be absorbed in the sanction pool. And you see, regulation, it should not be extended to the regulation 3, meaning thereby the new entrants.
Yes.
It has nothing to do with you. And so far as this case is concerned, controversy concerned, involved in this matter, according to our understanding, we find that it has no way.
Here, Your Lordship.
You will decide it independent of you.
Your Lordship, yes, I understand that. What I'm trying to place here, Your Lordship, is that the ad hoc employees and those appointed under 3F are excluded from the scheme of this new defined pensions. That's what I'm trying to say.
That is only on the basis of that 28 August 2007 communication.
So now, Your Lordship,
So then if you want to full-fledged respond,
I'll continue, Your Lordship, on the next step. Let it come as
Your
a...
case lies somewhere else.
I understand.
Maybe in the stipulation made in the new pension scheme itself.
No, this, it came from the department, that's why I had to... He said we don't involve those appointed under 3F, Your Lordship.
That's the case.
So we'll...
You see, you should rest assured that we may take it or we may not take it, but Mr. Shulai has conceded to the extent that it would be applicable
only to the twin.
So maybe there is some.
That is my alternate submission.
There is some loopholes there. So we'll see.
Lordship, since I also wanted to close this matter, I understand what my colleague is saying. It will not be to all the 38 others, which is admitted fact, Your Lordship. And in that case, Your Lordship,
But Mr. Shulai, you see,
Lordship.
even if we pass an order, the order will be applicable to those the petitioners herein. But if the others will follow, then you cannot stop them.
That is a different issue altogether, Your Lordship.
Lordship, can I make some sort of concluding remark, Your Lordship? I have already submitted a summary of my submission in the first stage of hearing, 2 copies given, and my colleague also received, and the judgments that I have relied, Your Lordship, already given. And perhaps I conclude, Your Lordship, by leaving it to the Honourable Court, Your Lordship.
Have you filed your written argument?
Written argument? No, we have not.
No, they have not filed.
We have not filed, Your Lordship.
Let him file yours. If he has already filed, then...
No, it's not a written argument, a summary of my submission.
Exactly.
Indicating where is where, Your Lordship.
If you wish to file your written note, then you do it.
Then we will file it, Your Lordship.
We take it that oral submission is concluded.
Concluded, Your Lordship.
Or Mr. Nishrai, Leonard AG, 4D, along with him, 4D.
Lordship, this only the synopsis.
And notes of argument, Your Lordship.
Notes of argument?
Notes of argument. Lordship, that will
At least
do it.
to enlighten us, not to confuse us.
No, Your Lordship.
That
is not my. It was never my intention, Your Lordship, to mislead or.
No,
Your Lordship.
I'm not saying that. I'm saying that whatever you have argued, make your written argument to the
concise.
Point.
Lordship.
So we may not have to.
Lordship, yes.
We may not have to wonder what you have stated, what you have argued.
Certainly, I'll do that. Lordship, we'll do that.
Apply, Your Lordship. You may supply a copy to me also of this.
We are not questioning your integrity,
Lordship,
your bona fide.
Your Lordship.
We hold you in the highest esteem. You've been, very, very cooperative with the bench and very competent.
Lordship,
so you deserve your position.
Lordship, my colleague also may supply a copy of that since I have already done so.
We'll do it. Your Lordship.
Much obliged.
Highly apply, Your Lordship.
considered.